So we've talked now about search and seizure in the Fourth Amendment. And what we want to do now is look at the next major constitutional protection in regard to criminal procedure. And that is, this is right against what we referred to, self-incrimination. So as we said, the Fifth Amendment protects us against self-incrimination, and I'll read it again. It says, nor shall a person be compelled in any criminal case to be a witness against himself. So the question is, what does the Fifth Amendment guarantee against self-incrimination really mean? And unlike the Fourth Amendment, which pretty much tells you how you have to apply this, you have to have probable cause and a warrant in order to have a reasonable search and seizure, the Fifth Amendment doesn't tell you how you must apply this right against self-incrimination. And what we've seen as a result is that case law becomes incredibly important. So what we want to do is try and figure out why it's so important and why did our founding fathers believe in this. At the outset of our criminal justice system that predated even the United States Constitution, the only basis for exclusion of testimony was this notion of untrustworthiness. Untrustworthiness. That for some reason, you would have to show that you could not rely on this at all. That there was coercion used, whether it was physical or mental, that allowed someone to say something that was untrustworthy. So the historical example of that was Brown versus Mississippi, where someone in custody was physically beaten and then confessed to the crime. And the Supreme Court said, whoa, wait a minute, that goes way too far. But does it have to be a physical beating? What about the case, Ashcroft versus Tennessee, where a person was subjected to 36 hours of continuous interrogation until they finally said, okay, I did it. What does that mean for ideas of voluntariness and coercion? Well, in modern times, the courts have gone much further in defining this right against self-incrimination. And the most important case in dealing with this is Miranda versus Arizona. And Miranda versus Arizona, decided in 1966, established the modern and contemporary standard for Fifth Amendment protections against self-incrimination. So let's talk a little bit about Miranda versus Arizona, give you some of the facts of the case. And first of all, what you have to know is this case was decided by a very narrow majority of 5-4. So there was a lot of debate among the justices. So the issue was, do the protections of the Fifth Amendment and its right against self-incrimination require that statements obtained from a suspected criminal defendant who is subjected to in-custodial interrogation require an affirmative procedural safeguard? In other words, even if someone voluntarily gives you information, can that statement be barred? Saying that we can only accept even a confession only after we tell you what your rights are. So when you look at this case, an incident occurred in Arizona on March 2nd, 1963. An 18-year-old girl who was mentally retarded was kidnapped as she walked home. She was taken into the desert outside of her Phoenix home and raped. She was then dropped off about half a mile from her house. Ernesto Miranda was a 23-year-old Mexican truck driver with a 9th grade education, and he's arrested based upon a description of the vehicle that she provided. He was taken to police station, taken into the investigation room, was not affirmatively told of any of his rights to an attorney or his right against self-incrimination, and the right that this information could be used against him in a criminal trial. At that point, the complaining witness did identify him as the person who raped her. So they brought him into the interrogation room. They subjected him to a series of questions and put intense pressure on him. And 2 hours later, they had a written and signed confession. Based upon this confession, which was the most compelling evidence at trial, he was sentenced to 20 to 30 years in prison. So the question on appeal was, should this have been admitted? And his attorneys are arguing that there has to be some kind of affirmative telling of a person's right against self-incrimination before we can ever consider a confession voluntary. How is it voluntary when you put someone in custodial interrogation and berate them for 2 hours? His attorneys continued, this was a police-dominated atmosphere. They used a lot of tricks to try and confuse him. They did a lineup. They had fictitious witnesses. They told him that a refusal to talk would be incriminating. His attorneys pointed to approaches that were put in the police manuals, that the police should maintain an air of confidence in the suspect's guilt, that their approach should be that they only want to confirm certain details, that they already know the person is guilty. At the same time, they want to minimize the severity of the crime. Oh, we understand why you did it. They want to put blame on the victim or society. And then only then, if they're unsuccessful in getting a confession, should they show hostility. So the question is, given those approaches, given those strategies, should that kind of confession be allowed to be used at trial? So the Supreme Court says, quote, the prosecution may not use statements stemming from in custodial interrogation if the criminal defendant is made unaware of their procedural safeguards. That once they are informed of their procedural safeguards, they can waive their right if they want to. And they have to show that it is being waived voluntarily, knowingly, and intelligently. That every criminal defendant must be informed of their right to remain silent, that any statement may be used against them in a court of law, and that they have a right to attorney. And this waiver must be voluntary. So what this case does is it establishes what we now refer to as the Miranda rights. So in every criminal show you see, when someone's arrested, they are informed of their rights. And then and only then can you ask them questions when they are in custody about the crime. And they do not have to answer. Now the question is why do we take this right so seriously? And again, think about the ramifications. So our founding fathers are saying, look, we don't want to give police officers, enforcement agents, an incentive to try and trick someone into a confession. When the ramifications of that are, they will lose their freedom. They can be improperly imprisoned. So that's why the court believed we had to have an affirmative right. Well, so the standard becomes it has to be voluntary, knowingly, and intelligent. And the question is, how far does that go? How far does that go? And when we look at that, we look at another interesting case called Rhode Island versus Innis. Which I believe was 1980. Rhode Island versus Innis. And this case was decided 6-3. What's going on in this case? Well, in this case, we see an individual who is suspected of robbing and murdering a taxi cab driver. So they get a description of him from another taxi cab driver, and they issue a bowler, be on the lookout for. And they see this individual walking down the streets who fits the description. So they arrest him, put him in the police car, and start driving him to the station. After he's given his Miranda rights, he says he doesn't want to say anything. So they say, okay, fine. So at that point, the two patrolmen in the car start talking to each other. And they start saying about, oh my God, did you know that there is a school for handicapped children in this area? And we can't find that shotgun. Geez, we wish we knew where that shotgun was, because it would be so terrible if one of these young children took that shotgun and killed another poor innocent child. At that point, the defendant interrupts them, and he said, I'll show you where the shotgun is. And he leads them to a garbage bin where they find the shotgun that has his prints on it. And it had been fired, and it matches the bullets that had been used to kill the taxi cab driver. So the question is,